Welcome to the next installment of our criminal law series, where we're delving into the intricate world of murder, building on our previous video where we explored the elements of a crime. The agreed definition of murder is that of Lord Coke's. Murder is when a man of sound memory and the age of discretion unlawfully killeth within any country of the realm any reasonable creature in rerum natura under the king's peace, with malice aforethought either expressed by the party or implied by law. But that's a bit of a mouthful. Thankfully, we only have to memorize murder is the unlawful killing of a human being under the king's peace with malice aforethought. And from this, we can extract the actus reus and the mens rea. At its core, the actus reus of murder involves the unlawful killing of a human being under the king's peace. And the mens rea is the malice aforethought, expressed or implied. Let's first unravel the actus reus layer by layer. What makes a killing unlawful? A killing is unlawful when there is no legal justification to do so. So, if a person has legal justification, then it wouldn't be unlawful. The killing wouldn't be unlawful. You're probably wondering when such a scenario exists. Let's take the case re A, where conjoined twins were separated to save one's life. Legal justification was sought and granted, rendering the act of separating the twins resulting in the other's death as lawful. Believe it or not, but killing has also been defined in a case. The case Adams. The judge said if her life were cut short by weeks or months, it was just as much as murder as if it were cut short by years. Thus emerged the legal principle, killing is the acceleration of death. So, an unlawful killing is an acceleration of death with no legal justification. But hang on a minute, what exactly is death? You'd think it'd be straightforward, but nothing is when it comes to law. Cases like Melcherick and Steele explain death is when the brainstem had died, stopped functioning. Hence, if a doctor pulls the plug, so to speak, on a patient's life support who is brain dead, the doctor isn't liable for murder as the patient is already deemed dead in the eyes of the law. There's also a case, Airedale NHS Trust v. Tony Bland, where Bland was in a permanent vegetative state. He wasn't brain dead, in fact, he was actually alive, but the House of Lords ruled that it was lawful for the doctors to withdraw the life-sustaining treatment and that the doctors don't have a legal duty to act and continue feeding him as there were no benefits to this. Hence, the doctors were spared the burden of omission-related liability. If the House Lords ruled that doctors did have a legal duty to act and they couldn't stop feeding him, the doctors would be guilty of murder through omission because they omitted feeding him. You only have to use these cases in an exam where the scenario is similar to the ones above, where they include either life support or someone with a dead brainstem. Unlawful killing. Check. 2 more to go. A human being is defined in law as when a baby is fully emerged, and that is illustrated in the case Paulton. To add to this, AG's reference number 3, 1994, includes a test for a defendant to be guilty of the murder of an unborn child. The unborn child must be capable of being born alive, it must be born alive, and it must subsequently die from the injuries sustained in the attack. Finally, the last part of the actus reus, under the king's peace. It's a very simple concept. It basically means during a time of war or international conflict, killing an enemy combatant doesn't equate to murder, and this is shown in the case Clegg. Then the prosecution must also prove the defendant's act or omission has caused the victim's death. And if you remember the previous video, I explained causation, but for this video, I'll quickly go over it. There are 2 types of causation along with 2 tests. Factual causation, which uses the but-for test from R.V. White, and legal causation uses the test from R.V. Paget. That's pretty much all there is to it. There are a few extra cases about the chain of causation, but I'm not going to dive into that here, because this video will be focusing on homicide. If the prosecution proves the defendant has satisfied the actus reus of the crime, he'll then have to prove the mens rea. Murder is a crime embracing specific intent. with intention as the mens rea. Not recklessness, just intention. Malice of forethought, either expressed by the party or implied by the law. That quote is from Lord Coke's agreed upon definition of murder. In the case DPP v. Smith, the House Lords clarified that the term malice of forethought has two meanings: express malice, which is an intention to kill, and implied malice, which is intention to do serious bodily harm, also known as GBH. If you watched the previous video, you'd know that intention branches into direct and oblique intent. Direct intention speaks for itself, but oblique intent is where students tend to trip up as it introduces a new layer of complexity. Oblique intent is where the defendant had a goal other than death or GBH, like to scare the victim. However, if death or GBH was a virtual, certain consequence of the defendant's actions, and the defendant could foresee this, the defendant would satisfy the mens rea of murder, and therefore would be guilty of murder. For more on oblique intent, explore the cases of Nedrick and Maloney. Those cases have legal principles you must memorize. And with that, this video draws to an end. If you have already learned this before, then I hope this video was a good refresher. Or if you are going to do homicide, then I hope this video has been a great introduction to it. In a future video, we'll tackle a 20-marker question on murder, solidifying our grasp on these concepts. Until then.